Thank you, Christy. The Iowa SBA Government Practice Section is really glad to be able to present these noon CLEs. What we want to do is be able to present CLEs that you can't get other places, that you have an option to get, and ones that you need. And we really think this is one of those. This is going to be Jeff Peter Elak from the Iowa Attorney General's Office discussing current issues in wrongful discharge cases. Before I introduce Jeff, I do want to mention we've got two more of these noon CLEs coming up. The first is on April 11th, 2016. Charlie Smithson from the Iowa Public Information Board is going to talk about new issues for their board. That'll be on April 11th, 2016. And additionally, on May 3rd, 2016, Roxanne Ryan, Director of the Iowa Department of Public Safety, is going to be discussing legal ethics in cyberspace. Are you maintaining legal confidences and secrets? And that'll be a great one for people to gather additional information in this era of technology. So Jeff Peter Elak is with the Iowa Attorney General's Office. He received his law degree from the University of Iowa School of Law in 1989. After law school, Jeff practiced for nearly 15 years with the law firm of Gallagher, Langlois, and Gallagher in Waterloo until coming to the Attorney General's Office in 2004. While in private practice, Jeff practiced primarily in the area of civil litigation with an emphasis on employment litigation. Jeff now serves as agency counsel for the Iowa Department of Public Safety and the Iowa Racing and Gaming Commission. In addition to those responsibilities, he represents several other state agencies in employment and other civil litigation matters. I'm glad and pleased to have Jeff presenting to us today. Thank you, Jeff.
Thank you, Mark, for the introduction. Thank you, folks, for participating in this webinar. I've done several presentations over the years for different CLE topics, mostly in the employment arena. It's the first time I've had to stand in front of a podium in an empty room and speak into a camera. So we'll see how that goes. I like to typically wander around, but I'm kind of tethered to this podium. And if I wander out of the picture, I promise you I'll be right back. My topic today is current issues in the area of wrongful termination or wrongful discharge cases. And we'll spend some time talking about several different topics on that. And I want to encourage anybody during the course of this presentation to ask questions. I'll try to pay attention to my screen to see if and when they pop up, and I have at least one assistant who's going to help me with that endeavor. So if anything that I'm speaking about raises a question in your minds, go ahead and I guess you can't raise your hand, but go ahead and type in the question, and we'll go ahead and try to answer it. As I mentioned, the topic is current issues in wrongful discharge cases. And you might think that since this cause of action has been around since, I think, 1988, nearly 30 years, that there wouldn't be current issues or undecided issues, but that's really not the case. And in fact, probably at any given time, I have a half dozen or so of these wrongful termination cases going on, and I have 2 or 3, I believe, in front of the Supreme Court right now. Just had one that came back just a few weeks ago involving some of the precise issues we'll be talking about today. I suppose the best place to start with any cause of action or any discussion on any cause of action is to talk about the elements of that cause of action. And again, you would think that since this cause of action has been in existence since 1988, that the elements would be pretty well established. And it turns out that that's not the case. Even back just last year, our Supreme Court in the Rivera case, which we'll be spending some time talking about, really addressed at least one element in particular, the causation element or the business justification element or non-element as the case may be. And in the course of that case, I think it's Justice Apple wrote that decision, and he referred to the elements of wrongful discharge as the oscillating elements, and in another part of that decision referred to the elements as not being sure-footed. And I think that for the most part, he was absolutely correct that there has been some disagreement in the cases over the years as far as exactly what the elements are and how they should be applied and what burden, who maintains the burden of proof throughout the cause of action. And I think I'll start talking just a little bit about those elements. Obviously, in a wrongful termination case, it's a situation where someone claims to have been discharged in violation of a public policy. At their essence, wrongful discharge cases are retaliation cases. I was fired for engaging in some sort of protected activity. So in that respect, from a basic framework standpoint, perhaps not significantly different than a retaliation case that you might have under the Iowa Civil Rights Act or Title VII. However, it's a common law cause of action. It's not a statutory cause of action. In fact, if you were to try to bring a cause of action for wrongful discharge in conjunction with a Title VII or a Iowa Civil Rights Act claim, it would be preempted by one or both of those statutes. That said, as far as the elements are concerned in a wrongful discharge case, in my outline, I put actually 3 different lists of elements in there to demonstrate really where we've come over the last several years as far as how those have potentially evolved. And the first set of elements, and really all of the cases are going to agree that you need to have a clearly defined public policy that protects some activity, and that the policy would be undermined in some fashion by engaging in that activity or terminating somebody for engaging in that activity. That's been pretty consistent over the years. What hasn't been consistent, and what we'll be talking about as we go through this presentation, is exactly what constitutes a public policy, how that's determined, and how that's addressed by the courts. Really the issue that has come up over the years from an element standpoint is this notion that started, I think, in the early 2000s, that the employer, or that an element was a lack of a business justification for the termination. In fact, and then whether that was, since that was listed as an element, stated as an element by the Supreme Court, is that something then that the plaintiff had to prove? In other words, did the plaintiff have to prove the lack of a business justification for the termination? And that was the precise issue that was discussed in the Rivera case. And as it turns out, the Supreme Court probably correctly pointed out that it's really difficult for a plaintiff to prove a negative, especially something like that, and that the business justification element, to the extent it is an element, was subsumed within the causation instruction or causation element on a wrongful discharge case. But that's just one example of a situation where even after 30 years of the existence of this cause of action, where the Supreme Court was still struggling with exactly what the elements are and how they should be applied. Now, if you look at the Iowa civil or the Uniform Civil Jury Instructions, there is a section, I believe it's section 3100, that deals with wrongful termination cases, and we'll spend some time probably talking a little bit about those as we go through these procedures or this presentation. Now, keep in mind that even though they're uniform instructions, they've been applied probably for years during the course of various litigations. They are really just suggested instructions. However, I think if we're going to cut to the point here, after Rivera, it's pretty clear that the uniform instructions are going to be accepted by the Supreme Court, have been accepted by the Supreme Court, and should be used in most of these cases. I think going back a little bit to the public policy component of the elements, to the extent that you might glean from my presentation, and certainly from my outline, that this presentation may be more defense-oriented than plaintiff-oriented, because, well, that's what I do, and a lot of the materials that I put into the outline actually came from briefing and other things that I've done in the recent past on these cases. But from a plaintiff's standpoint, and really from any person's standpoint, whether you're a plaintiff or a defendant, you really have to consider what is the public policy that you're going to be dealing with in this lawsuit. I don't know how many times I've seen a petition come into my office where the allegations are basically my client was terminated, the termination was in violation of a public policy, give me money. And that's really the extent of the petition. And quite frankly, that's probably good enough, and usually is good enough to get past the notice pleading requirements here in Iowa. But at some point, you're going to have to, I always say you're going to have to pick a lane. You're going to have to decide what the public policy is. You're going to have to identify the policy. You're going to have to defend it as a public policy that is actually recognized or would be recognized by a court. And it's really a good idea to think about that ahead of time rather than just filing something in a notice pleading and then hoping that something happens or something develops down the road to make it a public policy. Because the public policies, even though there's been a lot of things that have been recognized over the years as a well-defined public policy that would allow you to bring a wrongful discharge, I would submit that there are even more statutes and more policies over the years that have been determined not to be a well-defined and established public policy that you could bring a lawsuit over. So you want to always keep that in mind as a plaintiff. What is your public policy? How is it defined? Where does it derive from? And as a defendant, if that's one of the first things that you'll ask in discovery is please identify the basis for your claim that there's a public policy that the employer's been in violation of. What is it? Tell me what it is. How does it come about? What's the basis of it? Is it a statute? Is it an administrative rule? All of those things are important in determining whether the cause of action is even viable as far as stating a public policy that could be violated. As far as the elements are concerned, if you look at the Uniform Jury Instruction 3100.1, you'll note that they start right off, or it starts right off with plaintiff was an employee, defendant discharged the plaintiff from employment, and then they go right into describing the act that was protected by public policy. The issue of an existence or the existence of a clearly defined public policy, or whether it would be undermined by whatever activity the employee was engaged in, are questions of law. And they're questions that have to be decided as a matter of law. They have to be decided by the court before you even get to the point where you can instruct a jury. Those issues are usually raised. I often raise them on a motion to dismiss and certainly raise them in a motion for summary judgment to have the court determine as a matter of law whether what is being claimed is in fact a clearly established and well-defined public policy. I've had cases where over the course of the litigation the source of the public policy has changed multiple times. In fact, where the court disallows one public policy, the plaintiff will say, well, try this one, and amend their petition and claim yet another public policy, sometimes 2 or 3 or 4 iterations during the course of some litigation. And each and every one of those have to stand on their own. Each and every one of those have to be a recognized public policy for which a claim for wrongful termination can arise from. So you always want to make sure as a plaintiff that you know where your policy is coming from, and if it is something that's either has been recognized as a public policy that can give rise to a cause of action, and then as a defendant, obviously the opposite side of that, is it something that that hasn't been recognized or something that's in line with something that hasn't been recognized in the past. And make sure that those issues are decided as a matter of law, obviously long before you get to trial. I did have a case a year or 2 ago where we got to trial, and despite motions for summary judgment and motion to dismiss, we were still a week from trial, and there still wasn't a clear articulation of what public policy was at issue. And in that case, I filed a request for a status conference and essentially said, look, Judge, excuse me, you need to tell us what the public policy at issue is. You have to decide that as a matter of law. Otherwise, we don't know what we can. How would we present this to the jury? We can't fill in our proposed jury instructions. We can't do any of those things we need to do to get ready for trial. And if that was enough right there to prompt the judge to just a few days before trial finally grant my motion for summary judgment, determining that there wasn't a well-articulated public policy that was involved. So I think that as you look through some of these cases, even for some of the cases that have made their way to the Supreme Court, the issue of whether or not it is a well-defined public policy that can give rise to a wrongful discharge cause of action oftentimes isn't as articulated and developed as clearly as it could be at the lower court level, which then causes two potential issues on appeal. One is that you haven't preserved what you need to preserve on appeal. And then the other issue is, which is sometimes even worse, is you have too broad of an issue on appeal that gives the appellate courts then all kinds of room to decide potentially even issues that you haven't raised and issues that that might have a sweeping effect on not only your case but other cases. So can't emphasize enough to make sure that you consider what is a public policy, whether it's supported by the law or not. I suppose in keeping with that theme, we can talk a little bit about the public policies and what criteria the courts consider and whether it can give rise to a cause of action for wrongful termination. One of the problems, or one of the things I see over and over and over again, is a lawsuit that will actually point to a statute or point to an administrative rule and say, see, you violated this by terminating me because I was engaged in some activity that is covered by this statute, and as I said before, give me money. And you have to really carefully look at that, because there are a lot more statutes and a lot more administrative rules that do not give rise to a cause of action for wrongful discharge than do. And there are some criteria that have developed over the years as far as what the courts consider as far as developing a public policy, and they articulate that in their decisions, even the decisions that have come about recently with Dorschkind and Belalatek and some of the other ones that have come about just over the last few years. They set out the criteria. The Supreme Court sets out the criteria, discusses the criteria, but oftentimes when you look through it and you look through the criteria and you look through the ultimate decision, I've come to the conclusion, and I'm certain that folks on the Supreme Court would disagree with that, but it's kind of like, I think it was Justice Potter Stewart on the U.S. Supreme Court with pornography. They know it when they see it, and they do put out the criteria and they do address the criteria, they meaning the Supreme Court, and then ultimately there's a determination about whether or not it's a public policy that sometimes fits more closely with the criteria than others. Now, that said, virtually every cause of action that arises is going to have its basis in a statute. And the statute is going to be a statute that either impliedly or expressly provides some protection for a person or an employee engaging in that particular activity. Now, having said that, the folks that are listening are going to say, well, what about Dorschkind and these other cases that deal with, the Dorschkind was a case that deals with really an internal whistleblower complaint that was made by an employee on some, I believe it was forged training records or something like that. Then you have Jasper v. I think it's Nizam, that is also a cause of action that was ultimately based on an administrative rule. But if you look at those cases, both of those cases ultimately referred back to some specific statutory protections that were afforded to employees that engaged in that sort of specific activity. And so in its essence, you're still dealing with cases and situations that go back to a statutory protection for a specific activity. So one of the things that is often raised, as I mentioned before, is you have a situation where, okay, they violated the statute and I was fired because of it, I should be able to raise a cause of action. However, I think that our Supreme Court has recognized before, and really it's a matter of common sense, really every statute that is passed by the legislature, at least in theory, should have a public purpose. I suppose sometimes, especially this time of the year, we wonder about that, but ultimately there is a public purpose for every statute that's passed by the legislature. However, as I've mentioned several times already, very few of those actually give rise to a claim for wrongful discharge. The key is that the statute, the administrative rule that relates back to a statute, the internal whistleblowing that relates back to a statute does in fact relate back to a statute, but not just any statute. It has to be, and generally needs to be, a statute that has either expressly in its provisions some protection for engaging in this activity or reporting this activity. Generally that's what these cases involve, is reporting some activity, whistleblowing, turning in people for forging training records in a nursing home, turning people in for having too many kids in a daycare, turning teachers in for child abuse. Things of that nature are the things that are protected and have been protected for years in reporting or in establishing a public policy for a wrongful discharge claim. And each and every one of those statutes, in fact most of those, expressly provide protections for people that report these sorts of activities, even though the person that is reporting them may not fall directly into that category, which was the case in the Dorskin, which was the internal whistleblower case. So we have the public policy. You have a public policy that's been established, and then the other legal issue is whether the employee engaged in an activity that furthered that public policy, or whether the person's termination then would be a detriment to that public policy. And over and over and over again, I think that second element, as far as whether their participation in that activity was a detriment to the policy, is one that really naturally follows the answer to the first question: is there a public policy? And as our Supreme Court has stated really many times over and over again, that they have, and it's in my materials, and I'm citing to the Berry case, they have consistently refused to recognize the existence of alleged public policies based in general and vague concepts of socially desirable conduct, internal employment policies, or private interests. And the Supreme Court's really been consistent on that. Even if you look at, I'm trying to think, over the last several years, 2013, the Jones versus University of Iowa case, which is a case that I had that went up to the Iowa Supreme Court, and there were some internal Board of Regents policies that were claimed to have been violated. And even in that case, the Iowa Supreme Court said, no, that's not good enough. And you really have to. I had a case that just came down a couple of weeks ago where both the plaintiff and I raised the issue of whether there was a public policy with respect to a law enforcement officer in enforcing the law, for instance. And unfortunately, in that case, the plaintiff had filed a motion to reconsider, which ended up not tolling the time for him to file a notice of appeal, and that case got dismissed on that basis. But again, it's an issue that's been up in front of the Supreme Court, goes up to the Supreme Court pretty regularly, and will continue to do so. The issue, another issue that has come up a couple of times, are with respect to statutes that might offer some protection but don't necessarily apply to the citizenry as a whole. Don't apply, maybe applies to a certain number or limited number of people, and whether or not that advances a public policy. Yet another issue that comes up, as our Supreme Court has stated, it generally should be a policy that captures the communal essence and conscience of the community and affects the public health, safety, morals, and general welfare. Some of the things that you might think are commonsensical, that as far as the public policy, the existence of a public policy, really aren't. And one of the examples that I cite in my materials is I think it's Lloyd versus Drake. And in that case, you had a security officer that got involved in a student doing, he thought was assaulting another student, and ultimately that person was arrested, but it turned out to be not exactly as the security person had thought it was. And in that situation, the public policy that was claimed was, well, I was furthering the criminal laws of the state of Iowa. And the Supreme Court said, nope, that doesn't work. Too general. It's something that, yeah, it's a good thing. We all want to encourage furthering and enforcing criminal laws, but that's just too general in nature to establish a well-defined public policy. Another kind of counterintuitive, but I think legally accurate decision was the Balalatech case, where a supervisor in a company was asserting to his employer that, hey, you need to take care of these people from a workers' compensation standpoint. You need to cover them. They have a valid workers' compensation claim, and you're violating the workers' compensation laws if you don't do this. Well, that got the guy fired, and he filed a wrongful discharge case. And since Springer in 1988, clearly employees who file a workers' compensation claim and then get discharged because of that have a cause of action. But as it turns out, a coworker, supervisor, someone else just simply advocating for your workers' compensation rights, or even alleging that your employer was violating the workers' compensation laws, isn't enough. That's not going to cut it. And then there are some that I mentioned and list in here. The case of Berry versus Liberty Holdings is really sort of an interesting case in that the employee in that case was employed by an employer who owned several divisions of a business, and as he was traveling along, a truck from one division of his employer's business crashed into him, and he filed a lawsuit and was subsequently at least alleged to have been terminated because he filed that lawsuit. And the claimed public policy in that case was Iowa Code Section 668, the comparative fault statute, and really at its essence that I have a right to file a lawsuit for personal injury, and there's a significant public policy interest in allowing that. And our Supreme Court said, no, that's really too general. That's not going to work either. So there really, if you look at the cases, I think that if there's one thing or many things or a few things you can distill from that, is when you're dealing with things that clearly affect the health, safety, and welfare of individuals, those are things that are very likely to be recognized as public policies. Again, you have the examples of the falsified trading records in a nursing home, child abuse by teachers, too many kids in a daycare, things of that nature. When you go beyond that and get into real general, just good things to do, make you feel good, yeah, we should encourage those sorts of things, those are often not going to suffice to be a public policy. Now, having probably spent too much time on public policy, what constitutes a public policy, what does not, I want to turn to what really has become the $64,000 question in wrongful discharge, wrongful termination cases, and that is, do you have to be an at-will employee in order to bring a wrongful discharge claim? That's an issue that I have in like 3 different contexts up in front of the Iowa Supreme Court now. It's an issue that I've litigated in district court and a number of different times, and that is, as far from the Iowa Supreme Court standpoint, really still an unanswered question. Now, if you take a look at the Iowa, before I go into some of the particulars on that, somebody might say, well, look at the Iowa Uniform Jury Instructions. There's a comment under Instruction 3100.1 that says, note, this cause of action applies to all employees, including employees at will. See Conway v. Webster City, and then cites the Springer case as well. But if you take a look at the Conway case, which they cite in that, it really does not have anything to do with anything other than whether the Labor Management Relation Act preempts certain causes of action under Iowa law. And the Supreme Court in that case decided that no, the Labor Management Relation Act does not preempt it. You can, the district court has authority to hear such a case, and as I've been presenting to the courts for a couple of years now, several years now, that's fine. Yeah, we agree that the district court has jurisdiction to consider that, and they have jurisdiction to consider it just long enough to dismiss it if you're not an employee at will. Now, despite the fact that the Iowa Supreme Court hasn't directly addressed that issue, although if you look at their cases from the very beginning, the Supreme Court over and over and over again states that the cause of action for wrongful discharge is a narrow exception to the employment at will doctrine. That would seem to be a pretty clear indication that for decades the Supreme Court has indicated just that. It's an exception to the at will doctrine. If you're not an at will employee, you don't have a basis for bringing a wrongful discharge case. And the reasons for that, in my mind, are pretty clear, because you have other protections to challenge your termination if you claim that you were terminated in violation of a public policy. Now, as we talk about employment at will and whether or not there can be a cause of action for wrongful discharge if you're not an employee at will, the Eighth Circuit Court of Appeals has recently come down with a decision in Hagan, H-A-G-A-N, I believe it's in my materials, where in interpreting Iowa law, they clearly stated that based on those things I just mentioned, that all the decades of authority that has said, if you're not, it's a narrow exception to the employment at will doctrine, then you can't bring the lawsuit. And in that case, it was a doctor who operated under an employment contract with a medical group and claimed he was wrongfully discharged, and the Eighth Circuit Court of Appeals, based again on Iowa law, said no, you're not an at-will employee, you're not going to be able to bring your cause of action for wrongful discharge, and actually reversed Judge Bennett from the Northern District who had determined otherwise in that regard. There's also a number of other federal court decisions, many of them unreported decisions from the Northern or from the Southern District in particular, that indicate that being an employee at will is a factual prerequisite to bringing a wrongful discharge claim. It's axiomatic that you have to be an employee at will to bring such a claim. Now, as I mentioned earlier, I think I have 2, if not 3 cases in front of the Supreme Court where that's an issue. And I think as you consider whether or not a person who is not an employee at will should be able to bring a cause of action, you have to first really differentiate, I think, between the types of employees that could be involved. And I always envision them as kind of a hierarchy of people who are not at-will employees. And I always start with people who have statutory protections from discharge. And the ones that have been addressed, the ones that pop into my mind, are people like the law enforcement officers at the city and county level are protected by the civil service statute. There's also a statute in Iowa law, Iowa Code Section 80.15, that protects state law enforcement officers from discharge without just cause. There's also the state merit system, and I suppose since this is a government practice presentation, from that standpoint, there's the merit system, which clearly protects people within that system from discharge without just cause. And in those situations, there's a robust administrative process that's in place for employees to challenge these types of claims. And in fact, if you look at the civil service statutes, to some extent, I would argue that the question has been answered by the Supreme Court many years ago, back I think it was in 1996 with the Von Bale case that is recited in my materials, where the Supreme Court said with respect to Chapter 400 of the Civil Service Statute, a case that came out of the city of Des Moines, look, the legislature passed this robust process for you to engage in, so that's the process. That's the exclusive remedy. You don't get to bring any other claims for challenging your termination. So I would suggest that with respect to other statutorily protected employees, that may well be the case, whether it's a situation that you can't bring the claim because you're an at-will employee, would be one argument, whether you can't bring such a claim because it's the exclusive remedy, which would be the other argument, in fact, the argument that was essentially decided in Von Bail, and an issue that gets raised with respect to both the merit system employees and the state police officers who might fall under that statute, because you also, in addition to having sort of the Von Bail rationale, you have a Chapter 17A Iowa Administrative Procedures Act exclusivity argument as well in those situations. So you have the statutorily protected employees who, I think the argument that they need to have a cause of action for wrongful discharge really doesn't seem to make a lot of sense in light of decades of Supreme Court authority. The next step in the process as far as the hierarchy would be people who are covered by a collective bargaining agreement. And in that case, I've never seen a collective bargaining agreement that didn't have a just cause provision. And in those situations, and again, you have a robust grievance process that results in ultimately an arbitration, binding arbitration at the end of things. And so in that case, there's also an argument that there isn't a need to protect those employees. And in fact, one of the cases I cited in my materials, this Ackerman versus the state of Iowa case, raises, in addition to the collective bargaining issue, raises another sort of interesting issue, is that within the collective bargaining agreement in that case, and I should back up a little bit, in Ackerman, it was essentially a claim, a whistleblower claim under the whistleblower statute, and then also a wrongful discharge claim under the claiming that she was terminated for whistleblowing. Now, in the AFSCME contract, which governed her employment, there's a specific section in there that says you can't fire people for whistleblowing, and that's what was grieved, and that was the issue in that case. And I argued to the district court that exactly the same issue that is being raised in a wrongful termination case is being dealt with by a contract. This is a contract employee, and there isn't any need to do that. The district court agreed, and just last week the Supreme Court allowed the plaintiffs to take that up on their interlocutory appeal, so I suppose stay tuned. I also have a case pending that involves the statutorily protected employees under 80.15, and we'll see again in that from that category of employee where that comes down. So I suspect, depending on your perspective as either a defense attorney or a plaintiff's attorney, sometime in the next year or two, I'm either going to be making some really bad law or some really good law. Now, with as far as the hierarchy, as we continue down the hierarchy of people that that would be or may or may not be entitled to a to protection under the cause of action for a wrongful discharge claim would be the people who are just contract employees. And that was the case, essentially the case I just told you about a little bit ago with the Hagen case decided by the 8th Circuit. I would argue, at least as far as the 8th Circuit's concerned, that issue's been decided, and no, if you're a contract employee, you can't bring a wrongful discharge case. Now again, that's not been decided clearly by the Supreme Court, but it has, as I said, for decades been something that the Supreme Court has, at least commented on, that it is a narrow exception to the at-will doctrine. And then the other, I suppose, related to contract employees, but perhaps different in some respects, are independent contractors. And I separated independent contractors out for a reason, and that's because the Supreme Court in the Harvey versus Care Initiatives case said, as I pointed out in my outline, we find no compelling need, as we did for at-will employees, to support a wrongful termination tort for independent contractors. So arguably, you have people that are down the hierarchy as independent contractors that the Supreme Court has said really don't need to protect like we do at-will employees. You have people at the upper end of the hierarchy with the civil service folks who the Supreme Court has said we don't need to protect because they have these other robust protections. And so we're really, I think, left with the middle ground, and I would, of course, argue that since we've decided both ends of that to the effect that there isn't such a cause of action, that there really isn't any need to change that for the folks that might fall in the middle. I guess, as I said before, stay tuned. We'll see what happens on that. There was an issue that was addressed in the case that ultimately got dismissed as an untimely appeal, so the Supreme Court didn't get to that. But I think that is probably the most significant issue that the Supreme Court is considering right now in the wrongful termination arena. It obviously, if it's limited to at-will employees, that certainly narrows the folks that can bring such a cause of action. And if it's not, if the Supreme Court is not, that certainly opens the door to a substantial number of lawsuits that perhaps haven't even been tried before. I do want to, in case there are some questions, I haven't seen any pop up yet, but allow some time for questions. But I do want to talk a little bit also about some things that really are still potentially undecided issues, maybe some issues with jury instructions. And as part of that, I'll start with the Rivera case, which the Iowa Supreme Court determined that the issue of business justification was subsumed within the causation instruction, which is a determining factor. And those of you who do employment litigation understand that the two terms we deal with a lot are determining factor versus motivating factor. Motivating factor is clearly something that's contemplated under Title VII as far as the causation standard. Depending on whether you're a plaintiff's lawyer or defense lawyer, maybe something that is or is not the causation standard under Iowa Code Chapter 216. But clearly, after Rivera, it couldn't be more clear that for wrongful discharge cases, it's determining factor. And in fact, the Iowa Supreme Court in Rivera even commented that even if you were motivated, even if there was a motivating factor that was improper or illegal, as long as it's not the determining factor, the employer is still okay. So that said, if you look at the causation instruction in the Iowa Uniform Instructions that deals with determining factor in Rivera, the Supreme Court indicated that's just fine and certainly would suggest that you continue using that causation instruction. As far as sort of interesting unanswered questions, the one that I always puzzle over and quite frankly often lose on at the district court level is, should a pretext instruction be given as part of a wrongful discharge case? I've always maintained that because the pretext instruction really comes about in a burden shifting analysis like you would have in a discrimination case, that it really wouldn't apply to this tort because there isn't any burden shifting. And now, as I've said, I generally don't prevail on that issue. I know that Judge Bennett up in the Northern District has indicated over the years, and as there are some decisions from him, that these types of cases really do can be subjected to essentially a burden shifting analysis, so a pretext instruction should be given. The interesting thing about that issue, other than the fact it hasn't been answered yet, is if you look back to a 1995 case, Yaki versus the state of Iowa, the Iowa Supreme Court actually, over 20 years ago, had that exact issue presented to them and declined to answer the question of whether the burden shifting would apply in the context of a wrongful discharge case. So that's one of those that may end up there at some point in the future. Sort of an interesting issue as far as whether there should be a pretext instruction given. I think as a plaintiff you would probably want a pretext instruction, and you're certainly authority to support that. As a defendant, because it isn't or hasn't been decided by the Supreme Court to be a burden shifting type of case, and plus it gives the plaintiff another opportunity to poke a hole at whatever it is you're trying to use for your defense. As a defendant, you would probably not want that in most situations. Make sure that you make an appropriate objection, I suppose, whichever way it goes, whether you get it or don't get it. And I suspect that the next time it comes up to the Supreme Court, that particularly the Supreme Court we have now would be more than willing to answer that question if it were presented to them again. The other issue is, and I've seen this in discrimination, or I'm sorry, in wrongful discharge cases, and it really sort of puzzles me, is what we refer to in the discrimination context as a same decision instruction, which is, well, even though you might have been motivated by an improper purpose, the person would have still been terminated anyway. And I don't believe that in a determining factor case that a same decision instruction would have any place, because it's under motivating factor, clearly or a mixed motive sort of situation it would, but not under in the context of a determining factor analysis. Plus, if it's a same decision instruction in a discrimination case, whether it's a 216 case or a Title VII case, that precludes the plaintiff, if the jury finds on that issue, precludes the plaintiff from getting any money damages and is really only entitled to injunctive and equitable relief at that point. And I'm pretty sure that wouldn't apply in the context of a wrongful discharge tort. Perhaps it would be nice if it did, and then maybe it wouldn't be a bad idea from a defense standpoint to have that, but that doesn't make a lot of sense. And I think that what you see, at least in the cases I've had, for wrongful discharge cases, since there is some substantial similarity with discrimination cases, that the judges tend to, and litigants for that matter too, tend to just fall back on the instructions that you would get in a Title VII case or a 216 case and just throw those together, submit them to the court, and then kind of let the poor judge sort those out as he or she is instructing the jury. And I would suggest that that's clearly in the wrongful termination cases, that's not a good approach to doing your jury instructions. You should really think about these things. You should really think about the instructions and what effect they might have on your prosecution or defense of the case. And those are two that you really should be aware of. I think if you look at Section 3100 of the Iowa Uniform Jury Instructions, there isn't any pretext instruction that's suggested. There's not any same decision instruction that's suggested. And I would say that is probably an indication that perhaps there should not be such an instruction given. Now, having said that, there's also no instructions whatsoever for an Iowa Civil Rights Act claim, and then you get into the issue about whether you use the Eighth Circuit instructions or how you do that with respect to instructing on those issues in a Iowa Civil Rights Act case. I don't know. I'm sorry. Go ahead, Mark.
I got a question for you. You mentioned that you might have to review. You mentioned that you've got a couple of cases before the Supreme Court now. What issues do you think potentially could be coming down that people would be interested in?
Yeah, and I think I probably glossed over that when I was talking a little bit about those. The one issue is, two cases are statutorily protected employees. One, a merit system employee. One, a law enforcement officer that's subject to Iowa Code Section 80.15. And in that case, in those cases, as I said, those are the people that I would argue are at the top of the protected hierarchy, and either because they don't need the protections of an at-will employee, because of the robust processes that are involved, that they shouldn't be allowed to bring such a claim, or because of an exclusivity, the exclusive nature of that proceeding. The Iowa Supreme Court in the Von Bail case that I mentioned earlier said if the legislature passes a law that gives you these robust protections, that's the exclusive remedy. So that's one issue. The other one is the case that I just mentioned that got accepted for an interlocutory appeal last week, where the person was a collective bargaining unit employee and grieved her termination, claiming that she was terminated improperly for whistleblowing. And in that case, there's a specific provision in the contract that says you can't fire somebody for whistleblowing. That's what she grieved, and that's ultimately what went up to arbitration. Now, the interesting thing about that case is that when the district court dismissed it based on the arguments I made at that time, the arbitration decision had not come down yet. And in that case, the arbitrator sided with the state and said, no, you were not terminated for whistleblowing, you were terminated for legitimate reasons. And so in addition to potentially having the issue of whether or not a contract and covered employee that has that specific provision in their contract should be able to bring a claim. Ultimately, there's probably going to be an issue as far as whether there's some preclusive effect arising from the arbitration decision relating to that termination, but that won't be before the court yet.
I've got one more question. It's not exactly on wrongful discharge, but it relates to the last case that you had said came down from the Supreme Court for you. And so you file a motion to reconsider, file a motion to address issues that the district court didn't fully address, but yet you're subject to the appeal time period. Well, some of these cases are being thrown out. What is the court telling us with regards to those motions in real time?
Yeah, if you look at the Headland decision, which is the one that just came out a couple of weeks ago, clearly the Supreme Court does not like the rule that indicates, or that has for decades said, if you file a motion to reconsider that essentially rehashes the issues or doesn't raise any new issues, then that does not toll the time to file your notice of appeal. They clearly do not like that rule. They indicated in the Headland decision they're likely to do something about that, but that's what the law is now, that's what the rule is now. And so that's one of those things that whenever you file a motion to reconsider on something that's dispositive, you really have to be careful about that. And in this case, in addition to our argument that there weren't any new issues raised, there's another issue because that case was decided on a motion to dismiss. A motion to dismiss can only be decided as a matter of law. There aren't any factual issues, there aren't any factual disputes, so are you even able to bring or file a motion to reconsider if there aren't any factual issues involved? So there were two issues with that, but the caveat obviously is, when I did a lot of plaintiff's work in private practice, it always scared the heck out of me to try to do one of those motions to reconsider because you never knew whether on appeal the Supreme Court was going to say, well, that just kind of rehashed the same issues, or maybe that was a motion for summary judgment on that partial issue, so you didn't even have the opportunity to raise that. And in that case, unfortunately, you're left with some explaining to do to your client. Now, to be fair, in the Headland case, that was the matter was dismissed. We'll go through and deal with the remaining issues that are in play, and the plaintiff gets to raise that issue again at the end of the case, so it's not dead. And I suspect it probably will come up again unless the issue is decided in one of these other cases that I have. We don't. If we don't have any further questions, I really don't have a lot more to speak about, and I do appreciate the opportunity to talk about these issues. I think they're important issues. They're current issues. I do apologize, as those of you who heard me speak at CLEs before, once I get started, I kind of tend to wander around and get off track a little bit and talk about whatever happens to interest me. Hopefully it interests you folks too, but there are issues that are of interest to me. There are issues that should be of interest to anybody who's doing this type of work, and especially the issue of whether a person who is not an employee at will can even bring this cause of action is something that's very, very current, and is something that is going to be decided, I assume, in the fairly near future by the court. I thank you folks for listening in. Hopefully you found it worthwhile, and in the few minutes we have left, if there are any questions, I'll be happy to entertain them. Thank you.